you get hurt. Unfortunately, some people get killed, and over time, that attitude finally percolated up, and in 1970, President Nixon signed into law the OSH Act, and the purpose was pretty obvious. The statistics were staggering, and enough was enough. But I don't know if you all remember the Triangle Shirtwaist Factory fire that happened in Greenwich Village at the turn of the century. 146 workers had been killed in the factory, and they were largely killed because when the fire erupted, all of the doors had been locked because the folks that owned the factory didn't want people taking breaks or otherwise stealing merchandise. So they locked the whole place up, and when it caught fire, tragedy erupted. So it's kind of odd that even after that, it took decades and decades finally for the Occupational Safety and Health Act to come online. But again, history at the turn of the century wasn't safety conscious, and there's a lot of folks these days that don't quite get the picture. You can see the photo of this gentleman. I like the booze in the background. I guess they're planning a party after he gets shocked. And I'm sure those of you who are in the safety industry have seen these types of photographs before. I think I've been to this particular factory in Oklahoma. So needless to say, even though the Occupational Safety and Health Act has been around for a long time and OSHA has been around for a long time, there's a fair amount of folks that quite don't get the picture. That being said, the point of this presentation is to give you advice on how to avoid an inspection catching you off guard. I'm going to repeat myself on a couple of the main points, so forgive me, and I'm going to try and run through the presentation as quickly as possible and give you some in the field. I think folks really like the actual anecdote and real life experiences that I've experienced anyway. They're going to show up unannounced. So if you don't plan now, even on smaller job sites that involve remodelers, you're going to be caught off guard. And so if you know these points up front, then it's really important for you going forward. And unfortunately, if you have a fatality on a job site, that's one of the worst possible days of your life, because not only has somebody passed, but you have state police, you have OSHA, you have all kinds of regulators swarming a tragic scene, and it's very, very difficult to deal with that if you're not prepared in advance. Obviously, if you have a fatality, OSHA will almost automatically consider referring it for criminal prosecution from the U.S. Department of Justice. If OSHA does determine that a fatality on your job site was the byproduct of a willful OSHA violation, then they will seek or they will take seriously the prospect of prosecuting you criminally. So it's being unprepared is a bad place to be, even from the civil liability standpoint or even the OSHA citation standpoint, because not only will you have to pay penalties, but it's going to hang over your head for a number of years. Things to consider in advance is your relationship with the OSHA area office if you have one. Maybe you don't have one. Tailoring the inspection for this specific workplace. I handled a case for the Twinkie Company years ago down in Wayne, New Jersey. And we had one of our maintenance supervisors went out to the sugar silo. It's a massive facility where they made Suzy Q's and Twinkies and you name it. And this silo outside of the factory, all that did was meter out sugar. So if the Suzy Q line needed more sugar, they pressed a button and hydraulically powdered sugar would go through these pipes, and it always got jammed, almost always got jammed. So the maintenance supervisor went out to unjam the sugar silo, and there were 3 switches that shut down and to perform what's called lockout tagout. I'm sure many of you know. He shut down 2 of the 3 switches. We don't know why he didn't turn the 3rd switch off, but that's the one that worked the auger. And he put his hand up inside and lost 2 fingers. OSHA caught wind of this and came to the front door and announced their presence. And after the closing conference, all they wanted to see was a sugar silo. It was the only reason they were there. And instead of taking them outside the facility to the sugar silo, they walked the OSHA compliance officer through the entire facility in a very roundabout way. And that walk generated a ton of citable offenses from OSHA's perspective. It's what's called plain view. So tailoring the inspection prep for your specific workplace, that was one thing I'd hoped that the HR person had known in advance, and they didn't. Anticipating issues that might arise. If OSHA's showing up because you've had a settlement before, they're going to be looking for the issues that were in play in the previous settlement. Obviously, if they're there because of an accident, those are the issues that are going to be in play. Reporting requirements are always important to know in advance. A lot of folks scramble to figure out, gosh, do I have to call OSHA? And it's pretty straightforward as to when you have to call OSHA. This is the reporting requirement, not the recording requirement. And inpatient hospitalization of one employee, that is one that gets folks a little bit confused. They have to be admitted to the hospital before the 24-hour clock starts to tick. If they just go in for observation and then come out, then there's no reason to report that. Obviously, if you have an amputation or an eye loss or fatality, you have to report that. And missing those windows, 24 hours or 8 hours, is a separate violation. There are almost all of my cases involve compliance officers who come off, and these are OSHA compliance officers who come off as pretty friendly and understanding. And oftentimes when it's a first inspection for the employer, they will call me and say, "Hey, OSHA was here. I don't think, I think it all went really well, but then I was shocked to get these citations. They're very onerous." Well, that's because OSHA is not there to help. Believe it or not, when the enforcement arm shows up at your door, their job is to issue citations, and they take that job very seriously. And there are a few, especially ones up here in New Hampshire, that I call choir boy killers. They're very friendly, almost too much so, and they are very, very disarming. And next thing you know, you're facing down a willful or a repeat, and you go, "Gosh, I thought that inspection went really well. I thought they were here to help me." Well, they're not. And so you have to view them not as the enemy necessarily, but you just need to be on guard. You don't want to hand them anything that they haven't asked for, because let's face it, you want to protect your workers, you want to protect your subs workers, but you also have a business to run, and you don't want the government to make life any more difficult than it already is. Your goals in advance of an inspection are pretty obvious. You want to make sure that you want to minimize your operational disruptions. You want to control all the information that you give to OSHA. You want to try and read the tea leaves, so to speak, and identify their concerns early on, and obviously you want to minimize liability. Who's going to, and these are some issues to consider in advance. Who's going to determine if OSHA can inspect or obtain a warrant? Now, I never suggest that an employer should tell OSHA to go get a warrant. That's usually a recipe for disaster. We always want to have, and my theme is always, we're here to cooperate. We're absolutely here to cooperate. But this is an important point to note. You have the right to make them go get a warrant. And you'll probably waive that right and allow them in. But make sure somebody's understanding that they have the right to do that. If you want to exercise that right, number one, and number two, it it helps you to control where OSHA is going to go. During the opening conference, they have to tell you where they want to go and why. You say, okay, that sounds reasonable. I'm going to waive my right to a warrant. I'm going to take you to those places that you've just identified in the opening conference. But if they try to go somewhere else, then you say, whoa, time out. I waived my right to a warrant to take you to the place. Now you're unilaterally want to go someplace else. No can do. So that's a good way to kind of keep them honest, because they are supposed to conduct what's called a reasonable inspection, and agreeing to that kind of a protocol in advance is important. I always advise clients to have a walk-around team. Depends on how big your organization is, but figure out who the quarterback's going to be. Who's going to actually be? It's usually the HR person who's going to quarterback the OSHA inspection, the walk-around. Who's going to gather documents? Because if you have too many people running around grabbing documents, you just don't have a good organizational way to track what's been given. In my example of the Twinkie company, they came in a second day after they saw these plain view violations, and they wanted to do a wall-to-wall inspection. And during their wall-to-wall inspection, they just started grabbing documents. They went into the maintenance department and grabbed maintenance records. They went into the sanitation department, grabbed HAZCOM training records. And then when they left, the employer didn't have a record of what they had given them. Well, we think we gave them this. You didn't keep a copy? You didn't keep track? No. So it makes things difficult if you don't have a point person who's going to help kind of quarterback the OSHA inspection process. Arranging interviews, and we're going to talk about that in a little bit, and who's going to determine if you need to call a lawyer. And usually, if you follow the kind of the points I have here in this PowerPoint, 9 times out of 10, you're not. I'd love to be called every time, but you can manage your own OSHA inspection quite well if you follow these guidelines. They're going to conduct 5 different types of inspections. The things you worry about, and the things I would worry about, is if you have fatality or a major catastrophic event, then you're going to need some help, outside help, usually. Now, the opening conference is where OSHA will usually come to wherever you're working, a job trailer or the front office. And that's where you have the opportunity to ask, okay, I want to see your credentials. Now, I remember people would say, Laboe, come on, really? Someone's gonna impersonate a compliance officer? Yes, it's happened, and not too distant past for me. And one way it happened was internally at OSHA. Some of you may know this gentleman by the name of Stephen Nee. He works in the JFK building in Boston, and he's what's called a labor liaison. Every region in the country, and when we're up in region 1, has a labor liaison, or they try to have a labor liaison who is the go-between between the administration and local unions. Unbeknownst to everybody, OSHA decided to deputize Mr. Nee to go out and conduct inspections. And he had conducted over 100 inspections, issuing citations before he got to one of my clients, a bridge builder. And they allowed him to go through and conduct an inspection. It was completely unauthorized. And based on what we learned, he was there largely, upon information and belief, he was doing the bidding of the union, Carpenters Union. So we ultimately got all of the citations that he issued thrown out. But over 100 inspections were conducted by this guy, and many citations were issued to many different employers, and they were all invalid. But those employers didn't know it, and they ended up paying them and accepting the consequences of them. So ask for credentials up front so you know who you're dealing with. Now, this is when you can start managing, as I said. Press for an understanding of why you're here, what do you want to see. a clear understanding of the issues is important up front. So you know how to kind of guide the compliance officer to where they really need to go, and then manage expectations as far as where they're going to go, where their eyes are actually going to go, because we got this concern with plain view violations throughout every inspection. I usually like to make sure that the compliance officer knows in advance that we're going to have protocols, and those protocols are going to be document requests. They're always going to ask for documents. Please, 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 say to the OSHA compliance officer, send me your requests in writing. And they always do, through email. It's no problem for them. And it's important because you want to know what they're asking for, and you want to make sure that you respond properly. I have a very large concrete contractor who received 6 requests for documents orally, didn't receive it in writing. And they thought that it was only 5. And so they responded with 5 of the 6. And the OSHA compliance officer who was running the inspection erroneously concluded that they didn't have this final piece of documentation. And so because of that, they decided to launch a 3-person wall-to-wall OSHA inspection because they felt that there was something significantly missing. And I suspect, had they been more organized up front and asked for document requests in writing, they could have avoided that wall-to-wall inspection had they complied with the document requests. Other common protocols we try to make sure the compliance officers know up front is that you can interview employees, but they can't be lengthy. We can't disrupt what we're trying to do. If you need to really speak with somebody in private or for lengthy periods of time, let's schedule that in advance. So we usually try to get those protocols in place up front so there's no misunderstanding. Here's another trick. So the concept of management, anybody who is in charge of other people that works for the employer is, in OSHA's eyes, considered a member of management, even though you may not hold the management title. But if they consider a person to be in charge of other people, anything that person says is as if the employer is speaking. And so we're very, very careful not to have those types of interviews happen in private, happen audio tape or videotape. We're not going to have people who are members of management sign off on statements or sign off on compliance officers' notes because anything they say will be imputed to the company. And so we try to avoid that, because while we want to cooperate and we're going to answer all your questions truthfully, we don't want to create a record that may not be a full record. And let's keep in mind that these folks are not being prepared like they would be for a deposition. And if you, as a member of management, agree or make sure OSHA understands that you're not willing to have your statement recorded in any way, they have to honor that. That's part of their field operations manual. I have had, for Cincinnati Gas and Electric, we had a semi-explosion from coal dust. This is a coal-fired power plant in Cincinnati. And we did a walk-around inspection with the OSHA compliance officer, and they had a video camera. Back in the old days, when they had video cameras. And they put the camera down to their side, but they left it running while they asked questions of the management person that was on the walk-around team. And we caught him. We said, "Oh, wait a minute. We told you up front you can't record management interviews, and please stop running your camera." Now, I haven't had that kind of, that's pretty underhanded. I haven't had that kind of underhanded activity up here in Region 1, knock on wood, but be on guard, because they are looking for ways in which to build a case against you. And that's one way to do it. If your inspection involves industrial hygiene, like air monitoring or things like that, OSHA has to give you an opportunity to do parallel monitoring. And I assume most of you folks don't have industrial hygienists on staff. So they have to give you a reasonable amount of time to conduct parallel monitoring. Here's another thing. If OSHA takes a picture, you take a picture. I can't tell you how many times OSHA would say, no need to go back to the job trailer. I'll give you copies of my photos. They never do until push comes to shove and you're already in that kind of litigation mode. And it's very helpful to have photos side by side. So we're all on the same page and you're not beholden to them sharing with you the evidence from their own inspection. Another thing that's being introduced in recent months is the use of drones. I would say no to that. If you're in a situation where OSHA shows up with a drone, say no to that. It's just too difficult to maintain your walk around rights when the drone is, way over there and you have no way of controlling it. Yeah, you'll be able to look over the shoulder of the drone operator, but that's just not the same thing. And also you have Fourth Amendment rights against unreasonable searches and seizures. And they're going to go in, they can go into areas that they're not required, they're not legally able to go into with a drone. I would just say no to drones if anybody were to show up with a drone. Like I said, you have the absolute right to accompany the OSHA representative during the walk-around inspection. And I just had an accident up in northern New Hampshire where our client and the subcontractors were pulling fiber optic cable, and somehow the cable went low over the road. An 18-wheeler FedEx truck came through, struck the cable, broke the telephone pole, pulled it down on top of the worker who was in a bucket in a lift. High voltage electricity struck the worker. Thankfully, he's gonna pull through, but he got hit really severely with electricity. And the FedEx driver got out and said, "Oh, geez, everybody okay? I got to go do another delivery," and took off. And the sheriff had to track him down. But I'm kind of digressing. That example goes to the walk-around right. Because once OSHA found out about the issue, they showed up a couple days later when no one was on the job site and started to conduct its walk-around inspection, but never told our client, and actually started interviewing subcontractor employees without telling our client. And so that may become an issue later on because we're being deprived of our walk-around rights. Also, if you have a large walk-around team, whoever is on your walk-around team, make sure they understand why OSHA is there and where OSHA can go, and kind of what these protocols, about management employees not being audio taped or videotaped, signing off in compliance officers' notes. Make sure your walk-around team is fully apprised of the game plan. Because you don't want somebody running off willy-nilly and doing things that you've already agreed with OSHA is not going to happen. I'm going to go run and get documents for you right now. No, we're not going to do that. We're going to wait for the documents to come in writing so we can give a thorough response in one fell swoop. Make sure everybody knows that there's potential OSHA liability. Make sure everybody knows that when they're responding to OSHA, that they have to answer truthfully and accurately. Now that's obvious, right? We want to be truthful. And in fact, if you're not truthful with an OSHA compliance officer and you lie to them during an inspection, that's a crime in essence. Not even essence, I think it is a crime. So you don't want to, obviously you want to avoid telling deliberate falsehoods, but also, did you see it, taste it, touch it, hear it, smell it? Because if not, you're probably giving opinion, and you want to avoid giving opinion. That's not telling the truth, that's giving opinion. So make sure folks know that, you know, we're going to offer we're going to answer questions that we know the answers to, but we're not going to offer any opinion. Um, um, well, that was a question from the OSHA compliance officer in my fiber optic case. Why do you think that wire was why do you think the telephone pole broke and fell on top of the employee? We don't know really, because that shouldn't have happened. Wire should not have been that low. So you can get drawn into these. Well, let's give opinion, and then when you give opinion, it makes its way onto the OSHA compliance officer's notes, and it's an admission. So we can't do that. Refrain from admitting that a condition or practice is a violation. Oftentimes you could be walking on a site during a walk around inspection, and you'll look up and there's a worker who's supposed to be tied off and he's not tied off. Isn't that a violation of the Occupational Safety and Health Act? And 9 times out of 10, someone would say, yeah, I guess you're right. But no, that's a legal opinion. We're not giving legal opinions. Yeah, that should not be happening, and we're going to correct that. But I'm not going to say that's a violation. That's a legal opinion. By the way, knowledge is key. If somebody in management knew or should have known that that hazard was going to present itself, then maybe it's a violation. But if nobody in management knew that that was going to happen, then it's not. Now, paying close attention to OSHA's concerns is very important, because you can usually head them off at the pass, so to speak. I had a case up in northern New Hampshire for a wind farm that was being installed by General Electric, and we were putting it online. And our lead worker was up inside the base of one of the towers, one of the wind turbine towers, and his partner was coming up the steps and noticed that he was shaking. And he thought he was joking. And in fact, he was not joking. He was actually being electrocuted right in front of him. He had high voltage running through him, and he had locked onto the equipment. And thinking, remarkably quickly, this coworker decided to drop kick his friend off of the equipment so he didn't make contact with him and also get electrocuted. Guy hit the deck. He took gasps of breath, and then he stopped breathing. The coworker performed CPR on him, and by the 7th compression, he came to and said, "Oh my gosh, you just saved my life." And he got him out of the tower, and thankfully, these guys were pretty well trained, and he knew that it had the electricity been passing through his upper chest cavity, he didn't have long to live, because that would have cooked his innards, and that's usually a bad thing. Luckily, it went out his hip, came through his arm and out his hip, because he was touching another contact point. The reason I bring that up is because that was a very, very serious accident. And we paid very close attention to OSHA's concerns, and we fed them information about our training, how these guys knew how to do it right, how we could not have predicted this hazard. And believe me, there were issues in the case. But ultimately, we fed them enough information, because we were paying close attention to their concerns. At the end of 6 months, they said, "You know what? We're not going to cite you." And a near fatality case, and they didn't issue citations, because we were able to give them a ton of information, because we had them off at the pass. Again, everybody knows about the document flow. It's going to go through the quarterback, who you identify in advance. Make sure everybody knows that, again, and this is my point, is I'm repeating myself on the main points, but we're only giving facts that we know. We're only answering questions that we know the answers to. OSHA's not here to help, no matter how nice they may seem. And so everybody knows the script, so to speak, because again, you will be taken advantage of if you don't stick to these protocols. Make sure they understand the concept of plain view. We're only going to take the OSHA compliance officer to the place that they've identified in a manner that minimizes plain view. I put this. This is the point on hazard assessments. I put this slide in here because years ago the compliance officers never asked for hazard assessments, but now they're required to ask for hazard assessments. So if you've got personal protective equipment in use on your job site, you have to have a hazard assessment. They're going to expect it to be in writing. So be prepared to have that type of document at the ready. They're going to ask for 3 years of injury and illness records. When I say have documents at the ready, like I said, these document requests are supposed to be in writing. There are certain documents that have a 4-hour turnaround. Injury and illness records are one of them. The 4-hour turnaround rule is typically honored in the breach. They don't normally hold you to the 4-hour rule, but if they want to see them during the walk around, you can show them to them. Or if you have access to your injury and illness records by computer or electronic, any other electronic means is fine. Typically, if they want to see them during the walk around, show them to them, but later on send them to them. You got to make sure that they're up to date. Obviously, they're gonna have a problem if your records are not up to date. Should legal counsel assist? I always want to be there. I get paid by the hour, but oftentimes you don't need counsel present. You really don't. The times that you probably do need counsel present is if you have a fatality. I had a serious case up in Maine where an employee, they were working with a skid steer and they had the arms up on the skid steer. It's a major, one of the larger landscaping companies in Maine. And for whatever reason, these guys decided to take the front door off of the skid steer while the arms were up. And somehow the arms came down while one of the workers had his head under there, and it became an amputation case. It was awful. And statements were given on the day of the accident. And I went to the owner of the company. He called me 3 days later. And I asked him, did you talk to the police? He said, yes. I said, what did you say? He said, I have no idea. Did you talk to OSHA? Yeah. What'd you say? I have no idea. Fatality scenes are not the place to be answering these types of questions because you're in shock typically. And those are the types of cases that can carry criminal liability. So those are the types of cases that I'd want to get the call in advance so we can start controlling it. Look, you can't talk to our people until they've had time to decompress from this tragic event. And that's where we can come in, or I can come in, or whoever can come in and kind of run interference in a nice and respectful way. But they need to understand that that's not the time to be asking those types of questions. Insurance carriers obviously if counsel is going to be there, they can quarterback insurance issues that will arise, and oftentimes they do arise in significant cases. Production methods, you're probably not the audience that would have production methods that are implicated if you have to abate. So for example, lockout tagout. I represented the Consolidated Edison in Chicago, and we had a $500 OSHA citation, but the abatement method would have cost us $1.2 million. So that's what I mean by production methods are implicated. If your abatement method to fix the hazard, OSHA says, no, you got to revamp everything, not only here but wherever you work, that could be a problem. like I said earlier, make sure you mirror every photo or video that they take. We got a trade secret. I doubt you guys will have trade secret type issues. In the Twinkie factory, we had a trade secret issue. We had the machine that put the swirls on the top of the cupcakes. We said, look, you can't take pictures of that because that's a trade secret. We'll take the picture for you. We'll stamp a trade secret and give it to you. And they accepted that. But in the industry, construction industry, for example, contracts, they always want to see your contracts. And those are confidential. You don't want your competitors, through a Freedom of Information Act request, get your contracts. You know, a spurned competitor who lost in the bidding process, I'm going to go find out what they, you know, what so-and-so got for a contract. So make sure things like that. Keep in mind, when OSHA collects documents in their investigation, those documents are potentially subject to discovery to third parties through Freedom of Information Act. So I try to stamp as much of that as possible as confidential. Like I said before, hygiene inspections, you need somebody there to conduct parallel monitoring. Don't give them more unless it helps you. And usually that's where the lawyer would come in and say, you know what, if we gave them these training documents, even though they didn't ask for them, that would be helpful, because that will keep them from understanding that our people were in fact trained. But if they're asking for things like, are you supposed to make this available on request? Like Adrian logs, you have 4 hours. You got to be aware of that. Lockout tagout program. You got to be aware of that. You have to have that if you're conducting maintenance on equipment that could start up and hurt somebody. Is it reasonable? I think you're going to know if something is reasonable or unreasonable. A document request. We want all your accident reports for your entire history of being in business. That's obviously unreasonable. I want to see personnel file for employee X, unreasonable, and a violation of privacy rights. Make sure the document is responsive to the request. Don't give them a document that they haven't asked for, and you might be inviting more problems. Like I said before, if you get the document requests in writing, it's good to say, even if you don't have the document, you asked for, request number 5, you asked for this, we don't have it. So you've got a list of what they've asked for and what you've given them. I like the Bates number documents, and in some cases, there can be a voluminous amount of documents that you have to provide to OSHA. It's always easier to have it organized before it goes out the door. My pet peeve. Now, interviews. There are going to be interviews of non-supervisory employees. This is where OSHA gets the most evidence to support violations. And so, you really can't control these. But what you can do is you can meet with these employees in advance. I represent a firearms company who had somebody's face catch on fire, and they had to life flight them to Dartmouth Hitchcock. And so we knew everybody in the room during this accident was going to get interviewed. And so we sat down with them in advance because we knew OSHA was going to come. As you get life flighted, they call OSHA, and then they're there in the next couple of days. And so we had a discussion about how the accident happened. And then we reminded them of the training that everybody had received in relation to the processes at issues, and then we made sure they understood that you may be asked to submit to an interview with OSHA. It's your sole right to go into that interview. You don't have to do it. We're not telling you to do it. We're not telling you not to do it, but it's your call. Also, it's your call as to whether or not you want somebody from the company with you. And that's as far as you can go with non-supervisory employees before they're being interviewed. And then after that set down, the next day, OSHA did show up and asked to see the employees who were in the room at during the fire. And the HR representative for the client said right in front of the OSHA compliance officer, "Now remember, if you want one of us in there with you, you have the ability to ask for that." And the compliance officer took that as an interference with the inspector and with the inspection. And so the point of that is, let them know what their rights are and leave it there. It's up to them. But I will tell you, OSHA will have they'll have a fit if you try to insert yourself into the non-supervisory employee interviews. The best you can do is meet with them in advance, remind them of the training that they had received. Oftentimes OSHA will use terms of art, and oh yeah, I had, the chemical training, we didn't call it ASCOM. So it's always good to remind them of any training that they've received that might come up. And make sure, why am I being called in to an OSHA interview? So make sure they understand why they're being called in, and make sure they understand that they can be audio taped or videotaped. Now, this is where I've had a lot of non-supervisory employees say, "Yeah, I did not want to be audio or videotaped," so I told them no. "May I have you sign a statement?" I told them no. But it's up to you. It's important for them to know all of the same rights that we've talked about. We do try in advance to cover all of the questions that they might get asked. And then the most important part, and as Michelle said at the beginning, I handle whistleblower claims under the Occupational Safety and Health Act. Make sure the non-supervisory employee knows that, look, tell the truth. You're going to go in, you're going to get interviewed. Nothing you say in that interview will result in discipline or adverse change in your job. Obviously, if something has happened where you violated a standard, that's something else. Okay, we'll deal with that as something separate. But the fact that you're going to sit down and cooperate with OSHA, you're not going to be disciplined for that. Section 11C of the OSHA Act is a problem in that there's a lot of disgruntled employees who use it as a tool because they can make the federal government their own private attorney. And I can't tell you scores of frivolous whistleblower claims get filed, and it's like falling into a vat of quicksand because you can't seem to extricate yourself from the whistleblower docket because they're so far behind. I think it's many years unless you can convince the OSHA investigator to drop the case. It takes forever to get out. You don't want to get in it. So keep that in mind. So and don't walk into that trap. Don't discipline an employee. Certainly for cooperating in OSHA inspection. Don't discipline an employee who complains about what they consider to be an imminent danger. So that can get you in hot water. Oh, the point of this slide is that if you have unionized workforce, don't be surprised if union reps are called into the non-supervisory employee interviews because that is protected and there's no way around it. So don't be shocked if you see a union rep go into the interview room and you're not invited in. Now, I have these particular points to make on management present during an interview, but over time, I've found that it's very, very difficult to keep a positive theme going with the compliance officer if you insert yourself into the non-supervisory employee interview. So try to avoid that. But what's most important, and what I have seen compliance officers tell employers, is you can't talk to that employee about what we talked about. That is completely false. It's a misunderstanding. But you have every right to debrief the employee after they've been interviewed. Absolute right to do that, because whatever OSHA's concerned with on safety and health, you're concerned with. So make sure you debrief with the employee after they've emerged from their private interview. We've talked about management interviews. Make sure you have somebody present in the room. You need somebody present in the room taking notes during management interviews. Otherwise, you can run into problems. Had a major grocery chain, had a major that we all know, and had an accident, back room, somebody fell. And I went through the OSHA inspection file, and there was an interview note from the person in charge. Oh yeah, I brought that fall protection issue to upper management. They said it was too expensive, so we didn't do it. That's a willful violation on its face. And I went to the person, I said, Jay, who was with you during this management interview? He said, nobody. Is this true? He said, that is, not only is that not true, I didn't say it. But we had no witness to confirm that it had never been said. And ultimately I had to arm wrestle with OSHA. I said, I want the handwritten notes. I want the notes from that interview. I want the typed up one you just handed me. And I finally got the handwritten notes and found out Jay had never said any of that. It was not there in the interview notes, something they put in later. So management interviews are very important. You need somebody there taking copious notes. If OSHA decides they want you to demonstrate a work or process, don't do it. You're not required to stage demonstrations. And I had somebody stage a demonstration by recently, in recent months, by welding stainless steel and creating hexavalent chromium. When they weren't even supposed to be doing that. They do it from time to time, but they had no work planned in that area. They just did it to accommodate OSHA, and OSHA said, "Great, now we've got something to work with." And I see Michelle popping up.
5 minutes.
All right. Demands to stop work. OSHA's got no authority to demand that you stop work. Only a U.S. District Court judge can do that. Obviously, if you see imminent danger, correct it on the spot. Communicating with OSHA, like I said, in the wind farm example, we communicated with them. We provided them interpretation letters, trainings, all kinds of things. Flooded them with positive information that put us in the best light, and therefore we avoided citations. Closing conference, the compliance officer is going to tell you, yeah, we think you violated X, Y, and Z, but we're not going to tell you what penalties or classifications are. Press at the closing, you must press at the closing what exact regulations are in play. That's the main thing of a closing conference. Get out of it understanding which regulations are in play. After you get your citations, I insist on having an informal conference. This is the first opportunity to try and start a resolution dialogue. And you talk with the area director or assistant area director, and oftentimes, even if you don't settle the case, you learn something new or different. Penalties are high, and they're getting higher every year. For a repeat, 134,937. So if you take a serious today for $2,000 and get hit with the same hazard in the next 5 years, that could be a repeat carrying 134,000. So it's important to really take seriously the smaller citations up front, because they could become larger ones and then down the road. Do not miss the employer contest. 15 working days from the date you receive it to contest the citations. We always, I should say always, 98% of the time we resolve the case after the contest period. So don't miss that 15-day deadline. Usually your goose is cooked at that point. And so that's kind of it in a nutshell. If anybody had any questions, I had some photos from that. Well, there's the base of the wind tower. That was scary. Oh, these guys were running this particular machine inside of a dairy cooler. They were unconscious within a matter of minutes. Oh, geez. Building collapse at Bryant University. Thankfully, all my clients' employees came out of that unscathed. One more, Catherine, you had your hand raised?
I have a quick question. You said OSHA cannot stop work
That's correct.
if they're seeing an active violation, say on a roof, they cannot stop the progress?
So what happens is if they show up and they see an imminent, that's an example of an imminent danger. The employer should immediately correct that imminent danger, but an OSHA compliance officer cannot come on a job site and shut it down. It happens by inertia. Oh, OSHA's here, everybody wait, but they don't have the power to do it. And they abuse that power a lot, by the way.
Yeah, I think so.
Interesting. Other questions?
So the photo I'm showing you on the screen here, this is an example of how dangerous trenches are. This trench was no more than 5 feet deep, maybe 5 foot, 2 feet deep. No one was supposed to be working in it. And for whatever reason, the employee jumped in the ditch he jumped in the ditch. It caved up to his waist, and the pressure was so great, it severed his femoral artery, and he had passed away within 30 minutes. And it only went up to his waist, and they dug him out almost immediately. It was awful. It was awful. This is in Delaware last year. We were pulling down a building. This is an old GE plant. And the cable that we were pulling the building down got submerged into the pavement, broke, and came flying back. And it struck the gentleman on the right and threw him about 50 feet. And he was pronounced dead in the scene. And this just shows you, how crazy some things can happen and how you really can't avoid. And these are experts. These guys are experts in the industry, and things just happen. And you need to be prepared for OSHA to show up unexpected at any time. Granted, demolition is a high hazard industry, but the better you are prepared, the better off you're going to be to avoid downstream liability.
Anybody else? Any questions?
I do.
Yep, Greg.
So if OSHA doesn't have the authority to shut a project down that is just blatantly unsafe, is there any entity that has the authority to shut it down?
So what happens if the job site is just a seething imminent danger, and they won't shut, and the employers on site won't shut it down? What OSHA does is they go to the solicitor's office, and the solicitor goes to the U.S. District Court, wherever that is located, and they get an injunction and will shut it down. So that's kind of how that happens.
Still hours, if not days in.
It would be tough for them to get an injunction that day. I agree. Yeah.
Wow.
Now, responsible employers who see imminent dangers rectify them immediately. But if you've got somebody or a team that's just crazy, yeah, unfortunately, OSHA cannot do that.
Great. Very good. Well, Jim, thank you so much for being with us. This is always a wonderful, and it's always important to stay to the very end of your session so that you get to see the unbelievable pictures.
Kind of down. Yeah, I don't mean to leave everybody on a down point, but it's I appreciate it. Thanks, Michelle.
I actually have a quick question. If you
Yes,
still there. I've closed a couple of jobs down by just threatening. They would be paint where somebody's grinding paint, lead paint off an old building. The contractor will always respond by just stopping the job, but I don't know if that's ever put me in danger of any kind other than annoying someone. But if they're just that's a hazard it's a hazard to everybody, the passers by, the local elementary school next door, the kindergarten. So I feel that it's okay to do, but I don't know if there's any
right
legal.
So you're right. So general contractors, or what OSHA would call the prime contractor, who, if you have subcontractors working underneath you and you control them with your contract, OSHA expects you to have that ability to shut them down if they're working unsafely, and will hold you responsible under the multi-employer doctrine, if you are truly a general contractor or prime contractor, for the subs safety violations.
In this instance, I'm just an annoying passerby.
Yeah, then you've got no power to shut them down, and you're not an employee.
It's a threat.
Even though you may be exposed to the hazard, you're not an employee. So that wouldn't trigger the Occupational Safety and Health Act, but you have civil liability claims for exposure to lead paint.
Interesting.
Okay. Thanks.
Very good. Well, on that note, thank you so much, Jim. I really appreciate you being
got it.
here again this year. It's always a treat to have you. So,
Anytime. Thanks,
thank
all.
you.
See ya.
Great. So as we enter our final short break here for the day, I did want to mention that this particular break is sponsored by California Closets. They are another one of our great NARI sponsors, and we're grateful for their sponsorship support. They're not able to be with us today, but I did just want to recognize their commitment and support to the organization. So the other thing I want to do before I let you run for that last break is just mention a couple of things. First of all, the other thing I want to mention is 1 year ago today was the last time that I think we were all in a room together. That was our last live NARI meeting, was March 4th. So I want to kind of take a moment and acknowledge the this bizarre year that we've had, and sort of remark the fact that we have now been through an entire year's cycle of it. This conference was sort of the last event for us that we have experimented with going virtual. So I really appreciate all of you and your willingness to sort of come along on this ride with us as we learn this new environment and try and create the connections and deliver the information that I know that all of you value so much, but to do it in this kind of odd format. So I'm super hopeful that a year from today, we're in a room together, but I did want to note that it actually was probably a year since I saw most of you live in person. So March 4th is that date. With that, I did want to mention a couple of opportunities to connect that are coming up. Next Thursday afternoon, our Women in Remodeling effort. They are starting monthly conversations on the second Thursday of the month. This is sort of an ongoing small group dialogue format. So for women in the industry that are looking for opportunities to connect and share experiences, please register for that session next week. The following Thursday are our remodelers conversations. We've been doing this for nearly a year now, and I think has really come away with one of the greatest newfound ways that we connect as an organization during this past year. So that remodelers conversation is for general contractor members, and they meet on the third Thursday of each month in the afternoon, and just kind of a general open dialogue, information sharing and connecting forum. So I encourage you to register for that as well. So that's the remodelers conversation on March 18th. Also next Friday, Cody entries are due. So if you have a phenomenal project that you want to showcase for the Cody Awards, those entries, the paperwork is due next Friday. So we would love to see all of the amazing work that you all are doing in this year. Yes, Greg.
Is there a means to provide drone footage along with the Cody entry?
I don't know. That's a new question. I am sure that we can figure out how to make that work. It'll be a file size issue because the judging is all electronic, of course. And we give the judges a thumb drive of sort of all the images. So let's connect, and perhaps I can loop Joanne into that conversation as well to see whether or not what the file size would be on that, and whether or not, because that would be super cool.
If it was a link to a YouTube channel, with the
Some-
video, then
Yeah.
that
So
would,
yeah, let's have that conversation. That's a new question that we have not had before. So
all right.
I
Cool.
like it. Good. So let's connect afterwards on how to tackle that one. But anyway, so Cody entries are due the first Wednesday of April. I'm excited to announce that we're actually going to have a trivia night. So something really fun for our members. And the proceeds from that event are going to go to benefit the E.M. Neri Foundation, our scholarship fund. So look for that fun event. We thought we would mix up, lots of talk of code and lead and safety with something fun for a change for next month. And then, of course, fast forward a little bit, our Cody Awards, we're getting to be old pros now. We're actually in the second year of this cycle. Now we're getting to do things for the second time. So our virtual Cody Awards, we're going to do it virtually again this year. And that'll be the first Wednesday in June. So I believe that's June 2nd. So all of that is on the horizon. I did want to take a moment to just mention it. So here we are. We've got 7 minutes before our next session starts. So take our last little break, reconvene at 4:30, and I'll see you all back here then. Okay, we've got about 1 minute left of the break. Okay, folks, it's 4:30. I'm going to call everybody back for our last session. See if we can get folks to pop back on here. All right, thank you all for staying with us. We're on our final session of day 2 today. So this session is going to be for our lead CEUs called Lead Dangers. And our speaker today is David Canada with Lead Smart Training Solutions. So let me introduce David to you. David began learning construction at a young age on his father's job sites. Mainly focused in new residential construction in the suburbs of Boston, he was involved in the entire development process from land clearing through finish work, where he developed his love and specialty in hardwood and oak flooring. Since joining the Lead Smart team, David heads up our lead paint division department for renovations. His background in the trades and facility management bring depth to our team in the areas of NFPA regulations and OSHA standards. David holds professional certifications and licenses, including a CSL and a principal trainer in lead safe renovation work. So with that, I'm going to go ahead and turn it over to David to go ahead and David, at about 5 minutes of 5:30, I'll pop on and we'll go for questions. Okay.
All right, excellent. Thank you, Michelle, for that wonderful introduction. My name is David Canada. I'm with Lead Smart Training Solutions. I tried looking at the participants list a little bit to see if I might recognize any of you. I may have taught some of your classes in the past couple of years, as I've been teaching with Lead Smart for about just about 2 years now, and mainly doing the Lead Safe Renovator Supervisor class for here in Massachusetts, along with certain other things. I was also here at the last conference. I was wonderfully joined with our head of Mass DLS, Michael Weekly, if you all remember that last year. That was quite a treat. Anyway, today we're going to be talking about lead dangers. And let me just pull up the PowerPoint and I'll begin sharing that for you all. How has your day been going so far? You guys chat throughout, or is this always a one-way thing for now?
It's been going good.
Good. Excellent.
Yeah.
I popped on a little bit earlier and I saw, I'm not quite sure what the previous topic was, something to do with lead. I heard some lead questions. So I'm not quite sure how I'm going to be able to follow up a second lead section here today. Lead's not all that exciting to talk about, but it is required and quite dangerous. So make sure we get our sound going. Okay. So here we should have our presentation. Hopefully you guys can see everything here. Lead, quite dangerous. Only if you eat it or breathe it. And for those of us working around it in those pre-1978 homes, we are exposed to it, whether we live in these older homes or if we're renovating them. These old homes, pre-1978, that target year when lead was banned for the use in residential homes. So, the law that if you work in anything older than pre-1978, Massachusetts here, requires that we be a licensed contractor, a lead safe renovator contractor, which we'll talk about in a little bit more detail near the end of this session here. And if you are a business, right, you have to register your company with the state, the DLS, as a lead safe renovator contractor. And if we're physically working, if we're doing work on a project, on a home that was built pre-1978, then we need to take this lead safe renovator supervisor course, which goes into all of the details of how to work with lead safely, much more details and why it's dangerous, what we can do about it, and just how to work with it safely. You know, if you're a worker on a job site, it's very important we understand, you know, how dangerous it is and why it's dangerous, and then how to work with it safely so that, you know, we don't get sick while we're on the job site. That's pretty important. And then we also don't want to leave it around for our homeowners, the people we're doing our work for. We don't want to get them sick. And we certainly don't want to bring it home to our own family and get our own family sick. And so that Massachusetts Lead Safe Renovator regulation is sort of an addition onto the EPA's version. So hopefully I'm not reiterating anything that you guys have already heard here today, but that RRP rule, the initial rule created by the EPA, which all 50 states adopted, then of course Massachusetts, right, not good enough for us. So we had to create our own law in addition to that EPA's RRP rule, which is that lead safe renovator supervisor course that we have to take if we are working on lead projects. Anything pre-1978 here in Massachusetts. But that's not really the topic for today. You know, that's your 8-hour course to become that lead safe renovator supervisor, if that's something that you do. So, getting to this, whoops, sorry about that. So, a little bit of history of lead. You know, some of the stuff that'll just kind of make your head spin. We always look back at our previous generations and think, you know, what were you thinking? Right, they had all these great ideas, and then some of the stuff, it's just really that you thought that was a good idea, and some of this facts here, you know, I may not go into all of them in detail, but you know they are here for you. Maybe you guys can answer. In 1887, you see here, medical authorities first diagnosed childhood lead poisoning, which was later linked to being a result of, you know, lead paint. And in 1887, you know, that's the first medical reporting of it, where we really found out that it was causing issues in our young children. That's a long time ago. I told you 1978, that's a long time before 1978 where we actually did something about it. And now here you can see some things around the world that were done much before when we here in the United States decided to do something about it. As you see there, 1909, France, Belgium, Austria, and other areas of the European continent there decided to ban the use of white lead paint for interior paints. And National Lead Company, 1921, National Lead Company admitted that this lead was a poison. And National Lead Company, if you don't know much about the National Lead Company, they were, you know, around that time the #2 employer in the United States, the #2 employer in the country. And so when you see in the next year, 1922, when the League of Nations decided to ban lead paint, the United States, yeah, we'll figure out how to work with this, right? Because our #2 employer is the National Lead Company. Became hugely successful by selling this lead paint, creating this lead paint, and getting it everywhere. You know, throughout the country, you know, this lead paint, National Lead Company, they distributed this lead paint everywhere. All your major cities had a National Lead Company in it. We'll see some evidence of that in just a little bit. But, you know, United States, while the rest of the League of Nations, they all decided that this lead paint was not good for our children to be around, not good for us to be around. The United States decided, well, you know, I'm sure there's other ways we can deal with it, and we'll figure it out on our own. Now, some other information we see here, the CDC started reducing the acceptable levels for lead to be in our children, the acceptable levels for lead to be in our children, you might think, well, isn't more than 0 an unacceptable of level of lead to be in our children? You would think that, but here our CDC in 1975 began lowering the limit to 30 micrograms per deciliter. 30 micrograms. If you don't know what a microgram is, it's pretty small. A microgram is a millionth of a gram. A millionth of a gram. And you know, we learned in school that a gram is about a paperclip. So a millionth of a paperclip is a microgram. And here we see in 1975, the CDC said that 30 micrograms per deciliter in our blood is unacceptable, which really, as you can see the decline there, in 85, they lowered it to 25 micrograms. In 91, they lowered it to 10. And in 2012, they lowered it down to 5. 5 micrograms is what we're currently seeing as the acceptable level for lead in our children. 5 micrograms. 5 micrograms is not very much, and it still causes a lot of problems. Now, you know, as I said before, you know, Massachusetts, we're a little different. I'm sure you know that already. We're a little different here. And so we don't use 5 micrograms as our acceptable limit. You know, we use 5 micrograms here in Massachusetts as what we call an action level. The action level is like the red flag that goes up where it's like, something's probably wrong here. We should check out what's going on so we can prevent something really bad from happening. And so we use that as an action level here, the 5 micrograms per deciliter. 10 micrograms per deciliter in our children under the age of 6 is still the acceptable level of lead here in Massachusetts. You know, consider it just one of those things. You know how Massachusetts is one of the healthiest states in the country? Well, this is one of those reasons why. A little trickiness going on there, tricking the system, you know, where other states are considering anything over 5 micrograms to be, you know, poisoned. You know, our level is 10. And so that whole range there of differences is creating, is not really creating an illusion, but it's about an illusion, saying that we are healthier than maybe we actually are. If you recall, there was a steep drop in the healthiness of Massachusetts several years ago when we lowered it from, it used to be, I believe, 25, and when it was lowered down to 10, that's when Massachusetts took a little dive in the healthiness section for the country there. And that's why, you know, there was this whole group of people that were now considered, you know, poisoned and unhealthy, and it lowered our ranking there. So you can see some of these other stats here, you know, where in 1979, the New England Journal of Medicine reported links that lead exposure to the neurophysiological deficits in children, you know, creating issues with the nervous system and, you know, the way neurons function in our brains. The best way that I can describe how this lead affects us once it gets into our bodies is, you know, if you think about your brain like a pomegranate, you know, you've got a pomegranate, you cut it in half, you've got seeds with jelly around the seeds. Well, the seeds are, our brain is like memories, information that's stored in our brain. And the jelly is like the neurons, you know, the pathways that link information together. And when we want to think about something or say something, our brain sends a signal, you know, through with the neurons through the jelly to get the information out of the seed, and then, you know, that neuron travels back and we can communicate or, you know, whatever we were thinking about. Now, lead poisoning, what happens when we become lead poisoned, the lead disrupts the ability for those neurons to work the way they're supposed to. It's sort of like the jelly's dried up. So we don't really lose the information in our mind, but we might lose the pathways to get the information out of the seeds, you know, if all the jelly has dried up around that seed. So it makes it much more difficult for us to, you know, find the information, a longer, you know, response times, you know, slowed response time. That's a really good way a simple way of thinking about how our brains work and what this lead poisoning does to us and how it affects us.
Having problems. None of my pens are working very bad.
So
Can you come?
I thought it was very clever. Thanks, sir. I tried.
To stay alive, the human body needs a diet rich in items found not on a dinner table, but on the periodic table. Essentials such as calcium for bones, teeth, and muscle contraction, iron to transport oxygen, and zinc for growth and nerve functions. However, number 82, lead, is definitely one element that is not on the menu. Even tiny amounts can have severe health effects on people and other animals. And to make it worse, lead tricks your body to get in. Lead mimics the good elements your body needs, like calcium and zinc. Once inside, it replaces those metals, destroying important bodily functions.
You can think of it as sort of the lead hijacking your body system that it's developed to take up the metals that you need for good nutritional purposes.
By either breathing it or swallowing it, lead typically enters the body as dust. Since it masquerades as a needed mineral, the body readily accepts this deceptive toxin and sends it into the bloodstream. Lead poisoning can affect almost all parts of the body, but its effects are most pronounced in the central nervous system and brain.
right. So great illustration there of how this lead gets into our bodies and disrupts our bodily functions by masquerading as these other chemicals or as these other heavy metals that our bodies actually need. And so the biggest problem is that our bodies can't tell the difference between these heavy metals, the good ones and the bad ones, like lead. And so once we either inhale or ingest, eat or breathe this lead, then it enters our bloodstream and travels to our soft tissues first, dealing permanent, irreversible damage to our kidneys, our livers, our heart, and then it travels to our brain, dealing damage, affecting our neurons, the way that I described before. This lead can last in our bodies for up to 6 to 8 weeks. Right, that's about the time that it takes our bodies to really figure out that it's not something that we want in our bodies. And so, if we've stopped getting the lead, right, if we've stopped eating it, if we've stopped breathing it, if we've stopped being exposed to it, our bodies will naturally flush this lead out 6 to 8 weeks later. But if we keep getting it, right, if we keep getting it in small amounts, our body just continues to be tricked by it, and we'll continue to send that lead throughout our system, dealing damage, permanent damage, permanent irreversible damage. Those are some pretty serious words. Permanent, irreversible. It doesn't get fixed over time, and to us that might not be a big deal, right? If I get some lead poisoning and I get slowed down a little bit, it's not as big of a deal as if it was in a child, because I already know how to do everything that I'm doing. I'm not learning, I'm not developing processes in my mind. I'm not developing all these links of neurons in my mind to the different seeds to be able to grab that information quickly and easily. I know how to do everything already. I know how to speak, I know how to form sentences, I know how to do all the stuff that I do every day. Those are the processes in our mind that, as adults, we've developed over our time here. And the young children, they haven't done that yet. So it's much more dangerous in the young children than it is in us, because for several different reasons, mainly because their bodies are still growing and developing and expanding, their organs, their brains, and especially the younger children, right? The children under the age of 6, the target age when we're talking about protecting children is children under the age of 6, because they're growing so quickly. Their bodies are just expanding, constantly, and the really important developmental aspects of their brains and their organs really takes place during those young years, those early years, and the permanent damage that those children receive, it doesn't get fixed over time. and it could cause serious health effects that they deal with, throughout their lifetimes. Now you'll notice here, if you're reading the slide here, it says that, we can get this lead poisoning 20 or 30 years later. It can come back and get us. We're hopefully retired on an exotic beach somewhere, right? Hopefully, right? Fingers crossed. And we can still get this lead poisoning, even if we're not working around it or being exposed to it, breathing it or eating it. If we breathed it and ate it a long time ago, our bodies are the best tool we have available to us. Our bodies, the greatest tool, and really smart, good at planning for the future, really good at that. And so, when we're getting these heavy metals, our bodies, they're good at planning for the future. And so they think, well, what if I don't get this again later? I should probably save some just in case I need it. And so we store these metals in our bones, the warehouse, otherwise known as our warehouse. And then, when we're older, out on that exotic beach, not getting the nutrition that we need, our bodies have planned for this. Right? They go right into the warehouse, pull out those nutrients out of our bones, and we can get the lead poisoning one more time, because we can't tell the difference. And we think it's a good heavy metal that we stored in our bones, just for this reason, and then we can be exposed to that lead poisoning one more time. By putting it back into our bloodstream, it just causes the whole process to start all over. The permissible exposure limit of lead is 50 micrograms. Permissible exposure limit, the PEL, as you see there. Permissible exposure limit, that's a term that OSHA uses to identify the levels of lead that's safe for us to be around, to have in our breathing zone, right? The cubic meter that you see there, micrograms per cubic meter. That cubic meter is this, if you go 18 inches from, your breathing, your mouth, your nose, 18 inches in either direction, you've got this 18-inch or cubic meter, 18 inches in either direction or so, that cubic meter here. That's called your breathing zone. And this permissible exposure limit, OSHA says that as long as you're exposed to less than 50, you're safe. You'll be all right. But if you're exposed to over 50, now we have to protect ourselves. Personal protective equipment and other things to keep us safe. Ideally, we can reduce the hazard or eliminate the hazard so that we're not exposed to it. But if we are going to be exposed to it, if there's going to be more than 50 micrograms in this cubic meter, then we have to protect ourselves. And wearing PPE is how we're going to do that. Now, the action level, the AL, as you see there, 30 micrograms. 30 micrograms is really what most of the research agencies, associations like the industrial hygienists, they use 30 as their permissible exposure limit. That's interesting. If OSHA, our enforceable safety law, says that 50 is okay, why would these other agencies say that 30 is anything more than 30 is not okay? Well, simply put, OSHA is a negotiated law, right? It's the only enforceable law, which means it had to go through Congress, it had to be passed, and now it's an enforceable safety law. In order for that to happen, there's people on one side of the spectrum that say, we should have it really strict and we shouldn't have any of this stuff in our system. And then there's other people that say, well, how are we supposed to get anything done if we're working like that? So there's people on both sides that say, I want the number to be really high and I want the number to be really low. And so they negotiate and they meet in the middle, they compromise. And that's where the 50 comes from for our OSHA's permissible exposure limit. But, if we wait till we're exposed to 50, we're probably not going to get sick. But that's where the action level comes into play. The action level, OSHA's action level, is that red flag again, going up and saying, there's something we should do here. We're not quite at the danger level yet. We don't quite need to be protecting ourselves yet, but we should probably consider start monitoring the situation, measuring the levels of lead in our blood in case we are getting sick. Then we should do something about it. And so the action level That 30 micrograms per cubic meter is where the contractors, the business owner, the employer needs to start doing things with regards to medical monitoring, medical surveillance, and other things that in order to protect our workers on the job site.
Hey, Taya,
Understanding what we're
if you
being
get a chance,
exposed to on the
you
job site.
solve my sticky
with
pad
regards
crisis.
to measure the levels of lead that we're being exposed to.
You solve my sticky pad crisis.
Now, some of the health risks, as we talked about briefly before, more dangerous to our children for the simple reasons that they are the ones that are still developing their bodies, their organs, their brains. They're still developing all the processes in their minds that we already have as adults, and that permanent damage that they receive as a result of this lead poisoning, doesn't get fixed. And so it's really important we pay attention to those young children. And if lead wasn't bad enough already, it has a naturally sweet taste to it. I mean, come on. Doesn't get much worse now, does it? So let's just take a scenario for a second. If we have some lead paint chips outside, and our young children go out, find it, they don't know what it is. First thing they're going to do is probably put it in their mouth, right? The natural learning process. Put it in your mouth. They put it in their mouth to figure it out because they don't know what it is. There's not much you can do about that. And when they put it in their mouth, if it has this naturally sweet taste to it, if there's more paint chips on the ground, there are probably soon going to be no paint chips on the ground because it's got this naturally sweet taste to it. If it tastes good, they think it's good to put in their mouths. And what makes it really important for us to pay attention to is simply that fact, that it's going to taste good to our children, and they're trying to figure it out. They're trying to learn, well, what is this? And just like me, today when I go home, if there's a nice meal waiting for me on the table, I can't have just one plate. Right? That one plate is gone, and I'm trying to find another one. Where did that come from? I got to get more. And so your children, they'll probably about do the same thing. Right? They only just learn that it tastes pretty good. That's all they know. And so they're probably going to try to find more. And so it makes it really important for us as contractors creating this dust, creating this debris, not to leave any behind. If we leave it behind, the children find it. And now we're teaching them that this is something you should go and find because it tastes pretty good. So really important that we don't leave anything behind. And that's the importance behind that Lead Safe Renovator Supervisor course. If we're working on pre-1978 homes, how to work with it safely so that we don't get sick, other people don't get sick, we don't bring it home to our own families and get them sick, and we understand how to keep it contained and clean up after ourselves so that we don't leave it behind. Hazardous to our pregnant women. Our pregnant women or our women of childbearing age, they can pass this lead poisoning along to their unborn child that they're developing inside of them. Hazardous to all of us for several different symptoms here. The number one symptom, as you see listed there, high blood pressure. High blood pressure, the number one symptom of lead poisoning. High blood pressure. Now, if you go to your doctor and you had high blood pressure, the first thing your doctor is probably going to do is not, wonder what you do for work. He's probably just going to, give you some pills, right? Administering pills is about what modern medicine is these days. If you have something wrong with you, well, okay. Eat healthy, exercise more, and take some of these pills. And when you feel better, you can stop taking the pills. That's about what modern medicine is. No matter what's wrong with you, you get the cure for everything. Eat healthy, exercise more, and then, if there's pills for it, they can prescribe you some pills. It's hard for them to figure out why you have this high blood pressure. Doctors, they don't have the time to spend with you to really figure it all out. I mean, too many people, and there's not enough doctors. I learned the other day that A doctor needs to see 3,000 patients in a year, and depending on the organization they're with, but 3,000 patients a year. That doesn't leave a whole lot of room and time for you to figure out what's wrong with you and why you have these symptoms. And so they've got this in their toolkit. They've got all these things to provide to you. The pills is a great one. They give you the pills and they send you on your way. And they might work a little bit, but probably not all that much, because they're not solving the problem. They're not attacking the problem. Lead being the problem, lead being the cause of that high blood pressure. I think we're going to see on our next slide here some other symptoms of this lead poisoning, and they're just really common symptoms. Symptoms that we just all have as a result of working hard. And some of the other symptoms we see here: loss of sex drive or capability. That's a pretty interesting one. Seems pretty important. When I get to that section in my 8-hour day of lead supervisor training, most guys will be like, "You just start off with that," and I'm listening for the rest of the day. But so that's a big one there: loss of sex drive or capability, physical fatigue. If you were able to sleep for 6 to 8 hours a night, wake up, feel like you haven't slept at all. That's what lead does to you. It just sort of drains the energy out of your body. It makes it feel like you can't recover. Flu-like aches and pains, just like you've been beat up constantly. That's what it feels like to have this lead poisoning. Here's some more of those symptoms. This box over here, this box right here, low exposure level symptoms. When we have small amounts of lead in our blood, this is what we are going to experience. Things like headaches, irritability, reduced sensations, aggressive behavior, difficulty sleeping. Name one of your workers on a job site that doesn't exhibit most of those symptoms. You probably have most of these, right? These are symptoms of just working hard. It's a side effect of doing construction work. As I said, it's really difficult for our medical professionals to diagnose lead poisoning because the symptoms are so common. Right? If you go to the doctor, if you had a doctor's appointment tomorrow and you had headaches today, you probably don't even tell your doctor about the headaches. These symptoms are just so common to us that we don't even tell people we have it, because it's just going to go away on its own. I'm stressed right now. I've got a lot on my plate. All these projects coming down on me. Everything's coming to a head at once. And once it's all over, I'll be able to sleep in this weekend, and it'll just go away. That's what we think about this stuff when we have to deal with it. They're just not overly concerning. These low exposure level symptoms, when we have small amounts of lead in our blood, it's just not overly concerning to us. And then this box down here in the bottom left, abdominal pain, poor appetite, constipation, anemia. These are symptoms that we'll experience as our lead levels, start to get higher in our blood. We'll experience things like that. And children, they'll experience all these symptoms that we will experience, in addition to everything we see listed here in the yellow box. Loss of developmental skills, the behavior, attention problems, the hearing loss, kidney damage, reduced IQ, that slowed body growth because the permanent damage affecting the growth of those organs in their brain. Really important. We make sure we pay attention when there's young children around, whether on the job site or in our own home, right? It's probably more important to us that we don't bring it home to our families, because we don't want to cause this type of damage to our own children. And so what we're going to talk about a little bit now is some of the contractor obligations. I imagine, quick show of hands here. Let me see. Let me just pull you all up. Quick show of hands here. How many of you run your own business, whether you're a sole proprietor? I got most of you guys are hiding your video there. Just sole proprietor, business owner, something like that. You run your own business. Yeah, a bunch of you, and that's typically what I get in classes like this. You guys, business owners out there, really, it's not always readily available to us, the information on the requirements for us. But business owners, there are additional steps we need to take. All right, I mentioned the Lead Safe Renovator Supervisor Certificate, and that's the 8-hour course. Typically that's what I teach every day. That takes 8 hours. You go to class. Unfortunately, we can't do that online because there's a lot of hands-on skills. But that supervisor course is what teach you, the worker, to physically do the work safely. How to do the work so that you don't get sick, you don't leave it around for other people to get sick, you don't bring it home to your own families and get them sick. How to contain the area, how to clean up after yourselves, how to verify that it's been cleaned correctly, all the reporting that we have to do, the record keeping. All right, so that's the Lead Safe Renovator Supervisor course. That's what you physically take, you personally take, or your employees, your workers. That's the class you take to learn how to do it correctly. But business owners, you're the contractor, and there are certain contractor obligations. The license requirement, licensing requirements. It's not your CSL, it's not your HIC, it's your LSRC. LSRC, Lead Safe Renovator Contractor License. That might be a new one that you haven't heard of before. Hopefully, if you're doing this work on these pre-1978 homes, you have heard of it and you've got it. But if you don't, if you're a remodeler and you're working on pre-1978 homes, this is a requirement. And I know you're probably thinking, well, if it's a requirement, how come nobody stopped me for it before? I don't get a lot of credibility when I say that. But the truth of the matter is, it is quite important. The state has been cracking down a whole lot more recently. Just last year when all this COVID stuff hit, the government wasn't really able to work in their office anymore, and they were actually out in the field. They were, driving around more. They were looking for, contractor signs and contractors working in old homes. I can tell you, so everything shut down about mid-March. I remember, I think it was March 23rd is when I got the notice that we can't teach lead anymore in person. And so once everything stopped, we were able to start teaching a month and a half later. So in May, sometime in May, I was able to start teaching live classes again, with all sorts of restrictions and whatnot. But once we were able to start teaching again, my classes were filled with business owners because they had gotten a letter from the state that said they were in violation, simply because it was really easy for these GLS agents to go to the building department, get a list of permits that have been pulled on pre-1978 homes, and then they just compare your name with the list of licensed Lead Safe Renovator contractors, and if you didn't have the license, they sent you a letter. It was mainly in several towns that I got that got hit a lot. So I know you might be thinking, well, I don't have the license, and that didn't happen to me last year, and so what gives? Well, there was a specific towns that had a lot of that, a lot more of that going on than in other areas. But I can tell you, in the first month or so, in the first 4 weeks of my classes, I had about 60 different contractors come through that had gotten a letter. Because they were enforcing it quite a bit more, and enforcement is still up there. They are enforcing it more. This is a state level enforcement. I told you the EPA created the original RRP rule, but the EPA really doesn't have jurisdiction here because Massachusetts created our own law, and that's the Lead Safe Renovator Contractor license that we need to get. It's good for 5 years. I know, as CSL holders, we have to renew our license every 2 years. At HIC, we've got to renew, and this Lead Safe Renovator Contractor license is going to be good for 5 years. In order to get this contractor license here, what I'm going to do is I'm going to stop sharing this screen, and I am going to start sharing another screen because I want to show you. I want to show you just where to get some of this information. We're really big on not just giving you the information, but showing you where you can go to get the information that you need. So here we go. I'm going to share my browser. Of course, so the easiest way for us to tell you how to do it is to go to our website. So leadsmarttraining.com is our website. Now you can go to the state website, which I'm going to get you there in just a second, but if you have to navigate through the state website, you're probably going to get lost. And so it's much easier to navigate our website, I think anyway, to get where you want to go. So we have here our mass contractors link, and then this link here, mass forms. Now, if you click on this mass forms link, it's going to first take you to this EPA section. But once we click on this mass forms area, so one of the things we like to do is provide you an easy, one-stop shop for everything that you need. Here in this mass form section, all the documents that you need to actually do the lead work, right? There's, we've got all the laws posted here, but there's, non-certified worker training forms. There's your post-renovation checklist, the company application. So this is really why I took you here. The Lead Safe Renovator Contractor Company Application. So now you can search for this on the state website if you want to, or, the easier way is to just go here, click on this link, and we take you right to the state's download. So it's not like we're providing it for you. We're just providing you the link so that you're always getting the most up-to-date version of this license. So the application here, the reason I'm taking you here is so that I don't have to just, talk to you about the requirements for this license. I'm going to show you here right on the application itself. It tells you, what do you need to have? What do you need to have to get this license? So we'll go right through the checklist. Two different checklists. First, if you have employees, there's one checklist. And if you don't have employees, sole proprietor, working for yourself, if you don't have employees, there's a different checklist. But let's go through the checklist if you have employees, because that's the more difficult one. If you've got a business registered with the state, you've got to have that certificate of good standing from the state. So you've got to reach out, get that certificate of good standing from the state. This training certificate that we're referencing here, this is the Lead Safe Renovator Supervisor Certificate. Once you take that supervisor class, you'll get your supervisor certificate, and then you can send that in with your application. You also have to have proof of workers' compensation, since, right, you have employees, so you've got to have that proof of workers' compensation insurance. You also have to have this one here is a affirmation of compliance with medical monitoring. So we haven't quite gotten to that section yet. I mentioned it a little bit already, but the medical monitoring requirements, this is an OSHA standard. And guess what? Massachusetts are the RRP version in Massachusetts, the LSR law, we reference the OSHA standards in our law, which basically incorporates the OSHA law into our law. Let's just let that sink in for a second. That makes your DLS inspector also able to provide violations for OSHA violations. Now, if OSHA shows up on your job site, they can only issue violations for OSHA laws, OSHA regulations that you're breaking. But now what Massachusetts has done in our law by referencing the OSHA standard, we are allowing our DLS agents the ability to issue violations for the OSHA standards that we reference. And one of those standards includes some medical monitoring. I'll talk about the specifics to the medical monitoring in just a moment. But some other things we need to have here, this online payment. You need to pay for the license online. There's right there, you go there to that place, you pay online. It's $375 for a 5-year license from the state, which allows your company to sign contracts to do work. It doesn't even let you do the work, right? You have to take the supervisor class to be able to physically do the work. But this license here, once you have gotten all these documents, and so some of the things that it doesn't list here, but if we were to look through this through the application itself here, as you might notice, it's a 4-page application. And it's not going to take you a few minutes to fill out. There's some additional things we need to do here. This compliance with medical monitoring, you need to have a written safety plan which outlines your medical surveillance program. You need to have a written safety plan which includes how what PPE are you using? How are you keeping your workers safe that you're sending to do this dangerous work with lead, which is a poison? And then you also need to have a respirator program, a written respirator plan. Right? Because in order for us to keep ourselves safe, if we're exposed to 50 micrograms or more, which, let's face it, if you can see dust in the air, there's more than 50 micrograms in the air. And so if we need to wear these respirators, we need to have a written respirator plan. And it's not just, hey, we're going to be doing lead work tomorrow, so go pick yourself up a respirator from the store and make sure you get the right filters. You can't say that to your workers. You got to go through the fit test training, the fit test process, and have that written respirator program available. That's part of the application. So I know it's not listed here, but it's one of the things that you do need to provide as part of this application. Some written safety plans. You pay online, and yeah. So filling this out, one of the other things that's also not listed here, but if we were to go through it, you have to list all of your current employees and all your past employees for the last 12 months. The state wants to see how many employees you have, who's working for you, who's worked for you in the past. You got to have that list that you provide to them as part of the application. So now that we've seen the application and we know where to go to get the application, I just mentioned some safety plans that you need to have. A written respirator program. Now, this model respirator program, now this is not one that we created. This is one that the state has created for you. I'll just take you to it to show you here quickly. The state, as I just said, because you need to have a written respirator program for your company, the state's done you a favor. They've created a template for you to use. And it's not enough to just copy and paste this and then send it back to them, though. You got to take it and then tailor it, edit it, tailor it specifically to your company. But the reason I'm kind of showing this to you is to show you that if you don't have these written safety plans right now, you don't have to you don't have to really worry about it, because the state has created some for you. As you can see here, there's a model respirator program. There's also a medical monitoring program and your worker protection program. So the 3 written safety plans that the state requires that you have as part of the application process, they are providing you templates on their website. And we link to them here because it's difficult to find them on the state website, but we've got them here for you. So if it's something you need, they are available for you. And like I said, an easy way to get all the information you need, all the documents that you need, linked right on our website for convenience, simply for convenience. We want you to have the stuff you need to do the work that you're doing. And that's a great way that we like to do that for you. All right, so I'm going to get back to the presentation so we can wrap this up. We're coming up to the end very shortly. All right, so as we can see here, we talked about that license requirement. We talked about the training certification process, and now subcontractor roles. You might think that hiring those subcontractors, those independent contractors, relieves you of any liability. Independent contractor, I don't have to worry about it. Not so much. Part of the obligations of you as a contractor, the lead safe renovator contractor. Remember, specifically, that's what we're talking about. You as a lead safe renovator contractor are responsible for every subcontractor you bring on the job site. Not only are you responsible for your own employees, that's getting the correct training for your own employees, sending them through the respirator training, getting the right respirators for them. You're also responsible for your subcontractors. Right, the law, the LSR regulation states that all subcontractors must also be a lead safe renovator contractor. So now what does that mean? Not only you have to be the lead safe renovator contractor, you have to ensure that any sub you bring on the site who's going to be doing work needs to also be a lead safe renovator contractor. And if you don't require that your subs are also this LSRC, you're responsible, which means in violation of the law. If you don't require that they get the licenses, then you can be held accountable. It's not just, if DLS shows up, Department of Labor Standards, if they show up on your job site, you're the LSRC, you've got your workers as LSRS as supervisors, you've trained all your workers as non-certified workers, but you've got subs on the job site that aren't trained, that aren't licensed. They're going to get fined, but you're going to get fined too, because the law requires you be responsible for everybody you bring on site, not just your own workers, but also the subcontractors. And so that's a really important distinction to understand. You know, it's not just you taking care of yourself. You're in control of the whole job site. And as that lead safe renovator contractor, it's your responsibility to make sure that every person on site is trained to do it correctly, and every contractor is also licensed by the state. The best way that I recommend you do this, you probably use the same subs all the time, right? Unless there's an emergency and you can't really, and they can't help you out, you know, then you have to go find somebody else. But if you use the same subs all the time, if you do pre-1978 work, get it from them up front, right? You already get stuff up front from them already, I imagine. Certificates of insurance, their workers' compensation binders, but you get this stuff from them before you let them on your job site, I imagine. And they've been working with you for a long time. So every time it expires or comes due, they get you the new binder. This is one more thing you got to add to that list. Get it up front so that you're not scrambling for it when the time comes. You know, if DLS asks you, if they show up and they're asking you for licenses and certifications from not just your company, but everybody on the job site, you know, that's not the right time to go and ask them for it. You know, they expect you to have it readily available to show. So getting this stuff up front, you know, if you know they're going to do pre-1978 work for you, ask them for it before they get on the job site and just have it on file. If you're bringing that sub to the job site, you put it in the project folder for your PM to take on the job site. You know, and now you've always got it. You know, you can get the LSRC, you can get the LSRSs from, you know, all your subs in ahead of time. They're good for 5 years. You know, the certificate, the supervisor certificate, the contractor license, you know, they're good for 5 years. So get them up front, get them ahead of time, put it in your project folders, and then, you know, you'll be one step ahead. Medical evaluation. Medical evaluation. There's a lot to this. There's too much for us to really get into in the short period of time that we have here today. But I'll give you some brief details. So I see somebody's raised their hand. Is that for me? Do you have a question? If you have a question, feel free to just unmute yourself and speak right up.
If we are working in a pre-1978, we hire a lead contractor, abatement contractor, to come in and do the demo.
Mm-hmm.
Does that alleviate any of this other stuff after the fact, after they sign off and certify that it's all, you know?
So
done
the answer is yes and no.
Okay.
So
yeah, I figured.
Yes and no, right? The state law, the requirement of you as a contractor says that if you are going to sign a contract to do pre-1978 work, your business must be licensed by the state. So that's what the LSRC, the Lead Safe Renovator Contractor License, allows you to do. It only allows your company to sign a contract with the customer.
We are licensed, but I mean,
Okay,
if we don't
right.
want to do that lead work, we want to bring someone
Absolutely.
else in.
Absolutely, yes, you can do that. So you got the first step is taken care of, right? You got to be that contractor licensed by the state that allows you to sign the contract with your customer. But
Right.
what you're saying is you don't physically want to do the work, you want to hire somebody else. Absolutely, yes, you can do that. So that's where the yes and no comes into the answer. So yes, you can hire somebody else to do the work physically for you, but the no in terms of it doesn't alleviate you from anything in the sense that, you know, you still have to become the contractor yourself.
Right.
Right. So it's not just like, if I don't want to do anything with lead, I can just ignore everything I've just talked about for the last hour and just hire somebody else to do it for me.
I guess where I was going with that was, once this is more or less for the demo. So we hired a lead demo company to come in, do the demo. They certify that we're all cleaned up. The subcontractor roles that you were talking about, where we require those other subcontracts, the electrician, the plumber, whatever. Yes. Would they still need to be all certified as well or not? Because at that point, there's no more lead in the place.
Well, okay,
in
so
that room.
There's it's a little tricky. You know, just because you had somebody come in to do the demo doesn't mean there's no more lead there. I mean, unless you're completely gutting everything and everything is completely removed, you know, in that scenario, then maybe there is no more lead and there's no more danger. But we don't want to fall into the misconception that we had a demo company come in who was licensed and trained. They did the demo for us, and now we don't have to worry about anything else. If there's still painted surfaces around, if those painted surfaces will be disturbed, and that's the technical aspect of the law where it says if the lead, or not lead painted surface, because we're assuming that there's lead there. The law assumes lead is there. And so if there's any painted surface that's being disturbed, that triggers the requirement for contractor licenses and certifications, right? If paint is being disturbed. And so while you can bring in like company, like plumbers and electricians who might not, you know, get licensed to do this lead work because, you know, they're not doing lead work, as long as they're not disturbing painted surfaces, you know, that's where it's going to be acceptable. You know, so there are ways around it. There are exclusions, you know, part of, you know, there's a whole, you know, section in that 8-hour day where we learn about the exclusions to the law, where if we're not disturbing painted surfaces, you know, not everything applies to us. And so what you're suggesting is a great way to do that. Bring in a company who's licensed and trained to do it. They do the demo where we're disturbing the painted surfaces. But what they have to do is they have to create a scenario where those other contractors are going to come in and not have to disturb painted surfaces. Right? So that means, you know, cutting boxes in the wall, cutting, you know, the openings into, you know, if they're putting recessed lights in and stuff, you know, the demo company has to cut all and do all the disturbing of painted surfaces. And then it makes it acceptable for these other contractors to come in because they're not allowed to disturb painted surfaces. Right. Hopefully that was clear enough for you, because it does get a little murky. You know, it's not exactly clear water that we're looking through here, and so it can be difficult to really understand where the line stops.
So David, I'm here to give you your 5-minute warning. Okay.
Okay. Excellent. All right. I'm going to give you just a little information on the medical evaluation and respirator use, and then we'll open up the floor for a couple questions, whatever you guys want to talk about. So medical evaluations. We talked about it briefly earlier, that medical surveillance that kicks in when we're at 30 micrograms per in that cubic meter, which is not very much. If we're disturbing any painted surface, we're probably creating that 30 micrograms. Just one moment. Give me just 1 second. Sorry about that. Forgot to plug my laptop in. I got the notice that I was gonna die on battery. All right, so that medical evaluation. If we're exposed to 30 micrograms in that cubic meter, the requirements for the contractors to provide this medical surveillance to employees is going to require blood work every 2 months for the first 6 months. Blood work to make sure that these employees are staying healthy. They're working with lead, they're working with the poison, they're being exposed to this danger. We need to make sure that they're not actually getting sick. And so that medical evaluation includes every 2 months, we get their blood checked for the first 6 months of work. After that, it can drop down to every 6 months instead of every 2 months. But it does still require that testing every 6 months to make sure that they're not getting sick while they do this work for us on these dangerous job sites. The respirator use, respirators. Respirators are not a simple topic to talk about. You know, the training for a respirator, it takes about 2 hours to train somebody on how to use this tight-fitting half mask, tight-fitting respirator, and they're dangerous pieces of equipment. When you put a tight-fitting respirator on your face, it takes takes your body about 40% more stress, 40% more strain on your heart and your lungs to be able to use this respirator, to be able to breathe through this respirator. And that's a lot of stress on your body. You know, we're all different, and not everybody can handle 40% additional strain on your body to do this work, to wear a respirator. And so medical evaluation is also required before you can use a respirator. You know, going to an occupational doctor to be given a physical to determine that your heart and your lungs are healthy enough before you can put a respirator on. It's a lot of tough stuff, and respirator use is not something we should take lightly. If you are using a respirator and you don't know what the fit test process is, I highly encourage you to reach out to us so that we can help you through that process. We've just implemented, an online training program that allows the training of the respirator. You know, I said it's about 2 hours of training. You can either go to an in-person class to get that training where you learn, how to use it, how to inspect it, how to put it on, take it off, maintain it, store it, clean it. And what are the limitations? What do we do in an emergency? There's a lot of stuff to learn about putting a respirator on. It's not just putting it on and hoping for the best, right? There's a lot that goes to it. And, we did just finish developing an online program for that, as I mentioned, that takes the training. It takes you just like this, in an online session. It's not a live online session, but we've done our best to really make it as easy as possible for you to get that stuff, get access to that. Even if you're in a smaller company, we previously weren't able to allow this to smaller companies, but that online session really helps. All right, so
you want to open it to questions?
Yeah, sure.
If I take a minute or two, if there's folks with some burning questions.
Yeah, absolutely.
Anybody have questions for David?
David, can you just clarify for me? The individual employees have their lead safe renovators certificates.
Yep.
Does the company need to have the LSRC over them? And then, again, just like Ed, we would hire someone to do all the lead demo and everything and make sure they clearance test for us before we go in there. But
Yes.
Do we still need to carry that license as a company?
Yes.
Okay.
That the license, very simply, the simple way to understand how the license works, it just allows you to sign a contract with the customer. That's what the lead contractor license does. It allows you to sign a contract. So if you don't have supervisor certificates in your company, you don't really have to, because you're allowed to hire other companies that have it. Now, just like you might not be a licensed plumber or a licensed electrician, but you can hire them to do it. It works the same way. But in order to sign the contract with the customer, you have to have the contractor license, the LSRC.
Thanks.
Kathy, did you have a question? Kathy DeMar.
Have there, since COVID, have there been any extensions to the expiration of the licenses?
Yes, there has been. However, the extensions have expired. So last year, when everything got shut down, and yes, they did, but that all ended, I believe, sometime around October. So there's no more real exceptions or extensions to that. We've been putting live classes on since May. I teach about almost every day, lead in-person classes.
Okay, thank you.
You're welcome. Anybody else?
Do any other lead certificates or lead safety certificates from like Rhode Island, does that transfer over to Mass, or does any other state transfer over to Mass?
Yes, it does. So the supervisor certificate, you can be trained in an EPA state or, in Rhode Island, and you don't have to be trained here in Massachusetts, right? You've been trained on how to do it safely somewhere. Or the base law is still the same. The EPA's RRP rule, the base law, it's the same everywhere. States like Rhode Island also regulated like Massachusetts. So Rhode Island has their own law, just like we here in Massachusetts have our own law. They're different. I don't quite know the name of the regulating agency in Rhode Island, but there's their own regulating agency there. They have their own program. But if you've been trained in one state, there is a reciprocal agreement which allows you to be trained anywhere else and come here and still work. You have to be licensed by the state, right? The company has to be licensed by the state, so that doesn't change. But your supervisor certificate can transfer to any state.
Any other questions before we wrap up? Awesome. Well, thank you so much, David. I really appreciate you being here and sharing all this good knowledge about lead in an entertaining way. We are grateful for having you and the Lead Smart folks involved at NARI. Oh, Kathy, did you have a question? I see your hand there. Kathy Follett? Or did you lower your hand?
Giving him the clap because he did a nice.
Oh, yes, the clap. Very good. All right, guys. Well, thank you so much for participating in the conference. Joanne is going to be preparing the CEU certificates for you for the sessions. And I believe sometime probably early next week, she'll be sending those out. So it'll be shortly, but give her a couple days to get those turned around. There's a lot of things on the plate right now. If you do have any questions about your certificate, please just let her know. We were taking attendance for every session, so you will be marked for your certificate for the sessions that you were here. So if there's nothing else, I wish you all well, and I hope to see you all soon and have a good evening and a good weekend. So take care, everyone.
Thank you, Michelle.
Thank you.
Thank you.